Hey everyone, and welcome to today's video where we cover a courtroom moment involving one of the most difficult individuals featured on this channel. She repeatedly claims the right to remain silent while continuing to speak at length, which quickly creates confusion and frustration. This clip was shared with me by Tony B, and after seeing the title of her previous upload, it was clear this case deserved attention. Before we get into the hearing, I want to take a moment to thank today's sponsor, Raycon. The holiday season is approaching, and Raycon Everyday Earbuds make a thoughtful and practical gift. They are designed to be comfortable, stylish, and budget-friendly, which makes them easy to recommend. I personally use them while traveling, especially during long walks through European cities where comfort and sound quality matter most. The battery life is reliable with a charging case that keeps them powered throughout the day and quick charging that adds listening time fast. They also include features like noise control awareness mode and the ability to connect to multiple devices, which makes daily use simple and flexible. Millions of customers trust Raycon because the product performs well and is backed by a satisfaction guarantee. If you are looking to upgrade your audio experience, you can find more details through the link in the description and take advantage of current seasonal savings. Thank you again to Raycon for supporting the channel, and with that out of the way, let us move into today's courtroom story.
25mm6 set for case management. He is currently unrepresented.
Good morning, Ms. Williams. You're here for case management on one count of driving while license suspended, resisting or obstructing officer without violence, and failure to register a motor vehicle. My understanding is that you do not have an attorney presently, and I think I received a number of filings that you filed 4 filings this morning with the clerk of court. I had a chance to briefly review them. So, before we proceed, would you like to have an attorney appointed to represent you?
I represent myself.
Okay, so we'll address that in a moment. Mr. Helling, I think that I saw that Judge Bishop had notes in this case about having this case set for trial if there's no movement in this case, because I understand, Ms. Williams, you don't intend on entering a plea.
I'm sorry, I'm 75% deaf. I almost didn't hear any of that.
Sure, so I'll try to speak a little bit louder. Ms. Williams, my intent today is to set this case for a trial.
You're going to address the jurisdiction challenge?
Yeah, it's legally insufficient. It's denied. We have personal jurisdiction over you because you live in the state of Florida and you were operating allegedly a motor vehicle on the streets or highways of Union County. So we have personal jurisdiction over you. That's going to bring me to the next point, which is you indicated that you're pro se and that you do not intend on hiring or having an attorney represent you. Is that correct?
From this point on, I'm invoking constitutional law in this courtroom.
Okay, I intend to follow the U.S. and Florida Constitution, so we're on good standing.
And reserve all of my rights. And at this moment, I'm going to choose to invoke my right to remain silent. And because it's a criminal court, my silence cannot be construed as consent or guilt.
Okay, so here's what I'm going to do is I'm going to ask you some questions about whether or not you understand how to represent yourself. If you choose to remain silent, I will appoint an attorney because you've refused to answer my questions.
I reject that.
Okay.
I object. Excuse me.
All right. So, have you ever studied law?
Yes, for the last 4 years.
Have you ever represented yourself in a criminal action before?
I know, I stay out of trouble.
So is that no?
No, I never, does that matter?
It does, because it goes to your knowledge and ability to represent yourself as well as to understand and appreciate.
I'm very competent. I'm not to be presumed ignorant.
Okay. Do you understand each of the charges against you?
No, I do not.
Okay. So you are charged with one count of driving while license is suspended or revoked, which means...
What was the probable cause to pull me over?
So that's not what I'm asking you right now.
That has to be put on the record before any proceedings.
Okay, well,
by law.
So you were charged with driving while your license was suspended or revoked.
I wasn't driving. I was wrongly accused of driving
That statement makes no sense when examined under real-world facts. The officer observed you operating a moving vehicle in the normal and accepted meaning of driving. There was no alternative method involved and no unusual circumstance that changes that reality. Attempts to redefine driving based on online theories do not alter how the law understands the act. Years of misinformation can distort basic concepts, but courts rely on clear definitions and observable actions. In this case, the evidence supports that a vehicle was being driven in the standard legal sense, and that conclusion is straightforward and unavoidable.
I invoked and clearly, would you like to see?
I'm gonna be talking for a little bit, and so I would like you to listen to my questions. This isn't a chance for you to try your case. This is for me to decide whether or not you're competent to represent yourself at trial. Okay?
I am.
Well, I will make that decision. So you were charged with 1 count of driving while license suspended, 1 count of resisting an officer without violence, and 1 count of failure to register a motor vehicle. Do you know the maximum penalty for each charge?
No, I don't.
Are you familiar with the legal elements of each charge?
No, I don't recognize policy. I don't
That's
recognize
not my question, which
administrative law or statutory law.
Well, you may not recognize it, but it will be imposed on you, and if you are found guilty, the judge will impose a sentence whether or not you recognize it or not. Do you understand that?
If you force jurisdiction where there is none, you'll be open doors to impeachment and lawsuits.
Okay. Well, I probably won't be the judge trying the case, so that's okay with me.
Your Honor, if I may, I think that Judge Bishop has gone over these with her already, and she has once again maintained her.
Sure.
Proceed pro se.
I think that if I'm setting for trial, I think just to be safe for every stage, I'm just going to go over.
I'm going to say this is case management. It will go to pretrial next month.
Okay.
And then trial after that. So I think we're 1 step away for setting it full trial.
I'm going to fire any judge, any attorney that's been appointed to me. So.
Well, so I guess, Mr. Salter, if I set this for trial, would you be willing to be standby counsel just in case?
I think I would need to be, yes, sir.
Yes.
He's fired.
Well, you don't get a fire, you're standby counsel.
I do not consent to that.
Well, that's the thing about this is that
I have a right to represent myself. I've made it clear.
You have the right to represent yourself.
Yes.
But also the other part is that you have to be fully aware of all the risks that come with it.
I am. I'm willing to take any risks.
Okay. I'll just put it this way, having read your legal filings as well as the arrest report, I think you fundamentally misunderstand the laws and Constitution.
I am not. The Amish community has well kept up that right.
I'll just put it this way, I don't see many Amish people driving cars and using
you're looking at one.
What we are really seeing here is someone shifting identities whenever it feels convenient rather than following any consistent standard. That approach does not align with reality or with established rules. Amish communities traditionally avoid operating or owning gasoline-powered vehicles under their ordinance guidelines. That means the claim does not fit with the behavior being shown in court. Either the identity being claimed is inaccurate or it is being used incorrectly to avoid responsibility. Courts look at actions and facts, not changing labels, and those facts clearly do not support the argument being presented here.
Your Honor, we don't really have a trial week next month, so we'll just if you could put this on pre-trial conference for the next month, Judge Bishop.
When is our pre-trial conference?
June 10th.
All right. So it's the same day as case management?
Yes, Your Honor. We only have 1 misdemeanor court date.
All right. So I'll put your case on for pre-trial conference. Be aware that you are charged with driving while license suspended and resisting an officer. Both of those are first-degree misdemeanors. Maximum punishment of those consecutively would be up to 2 years in the county jail. Failure to register a motor vehicle, that's a second-degree misdemeanor, which is punishable after 60 days in jail. So you could find yourself spending up to 2 years and 60 days in jail on these charges. Do you understand that?
No, I don't. But
okay. So here's what happens is if you're found guilty, because what the state's required to prove are the essential elements of each charge.
I have all that.
The essential elements of driving while license suspended is that you were operating a motor vehicle on the streets or highways of Florida while your license or privilege was revoked or suspended.
I still don't
Whether or not you were
cause.
traveling, flying, or whatever you want to describe it, if you were in a car and that car was moving and you were operating that car and your license was suspended, then the jury would be instructed that all essential elements have been proven and they should find you guilty. Likewise, resisting an officer means that you resisted, obstructed, opposed an officer in the lawful execution of a duty, but you did not offer violence during that. If they find that you committed that offense, you would be found guilty and could be punished by up to a year in the county jail. So with that, you wish to have this set for trial?
No, I do not. But
Okay,
I
well,
wish
so
to
your
have it
options today,
dismissed.
your options today are to enter a plea or set it for trial.
You make the call.
Okay.
I'm not going with any plea, so
Okay, then we'll set it for trial. So that's how the case will be resolved. We'll set you on for June 10th for pretrial conference. Please sign notice, and we'll see you then.
thank you.
That brings us to the end of the first hearing, which was already intense and full of confusion. Even so, this was only the beginning, and the situation continues to escalate with each appearance. The next hearing takes place 1 month later and shows an even clearer pattern of poor decisions and growing consequences. Let us move forward to that second court appearance and see how things continue to unfold.
May I address the court, please?
That's why your case was called.
Article 6, Clause 2 of the United States Constitution says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding." This means no state law, no local ordinance, and no traffic code can override the the supreme authority of the United States Constitution, especially when it comes to the fundamental liberties of the people. I am here today as a special appearance, not because I committed a crime, but because I exercise a federally protected, clearly established constitutional right, which is the 14th Amendment right to travel in my private automobile without government permission or interference.
All right, stop. I don't have time to deal with this, and I'm not going to listen to this. Everything you're saying is absolute nonsense.
No, it's very true.
Stop talking. Don't talk. Don't talk. Everything you read about, when you read from the Constitution, yes, you read that correctly. Your interpretation and everything you think you're doing is absolutely wrong. The writ of prohibition that you filed in the First District Court of Appeal was dismissed yesterday, and we received that order, okay? I don't know what you think you're going to get by filing a writ of prohibition in the United States Supreme Court. If they even choose to answer that, we'll wait to see if there's an answer to that.
I will.
All of your claims are absolute nonsense, and I don't have time to deal with them. You were charged with driving on a suspended license, resisting an officer without violence, and failure to register a motor vehicle. Stop. Don't talk. The state attorney's offer to you is an adjudication of guilt, a $100 fine, court cost, and cost of prosecution.
Judge, to clarify that offer is no longer open.
That was the offer, okay? So there you go. The state attorney revoked the offer. Very, very good.
Situations like this show why some prosecutors choose not to extend leniency through special offers. Repeated misuse of the court system wastes time and resources and undermines respect for the law. Strong enforcement and consistent consequences can send a clear message that these tactics do not work. When accountability is applied firmly, it discourages others from copying the same behavior. The goal is not cruelty but deterrence and maintaining order within the justice system.
Pretrial conference. And I don't have time right now. I just don't. I have to end our docket today because I have another appointment to get to go through a Ferretta hearing with you right now. But you have indicated previously that you want to represent yourself, and so far you have been representing yourself, and with that being all the state had previously been asking for, that's all we would have done anyway. Okay. So you're not going to like anything I'm going to do right now, okay? And you're probably not going to agree with it. If you want to file all of the nonsense that you've written down on paper and file it with the clerk, you certainly can. And then you can appeal any decision that I make to determine whether or not I've acted within the laws of the state of Florida, okay? I'm going to temporarily, because I expect that you're probably going to want to represent yourself if that's what you want to do, but you do have the right to have a lawyer represent you, and it sounds like the state's going to turn a little harder toward a more severe punishment. I'm going to appoint Mr. Salter to represent you today. I want you to at least try to have a conversation with him. And if you don't do that, well, we'll deal with that later. I'm going to continue the pretrial conference to the July docket. And at that date, if you indicate to me that you want to represent yourself, then we'll have a Feretta hearing on that date.
That's fair.
I'm not going to hear anything else from you today. I don't have time to deal with it.
I understand.
If there's something that you want to file, you can write until your hand bleeds on your paper. You certainly are free to do that, and you can file it. Whether it has any merit or not, I'll make decisions that I have jurisdiction to make, and then the appellate courts can make decisions about the jurisdiction, about the things they have jurisdiction to make, to include my decisions and my legal opinions. Okay, I'm not going to deal with all of this today. All right. Sign your notice to appear for July 15th, and I'm appointing Mr. Salter to represent you for today.
I think that's the last case on the docket.
Okay, so that's the end of the second hearing. The judge is starting to get more and more frustrated with this soft-tard, and like I said earlier, it's going to get better and better. Now let's head to the third hearing, where it really starts to pick up.
Right.
Your Honor, just for the record, I know that you appointed me to represent Ms. Williams the last time. She has not contacted me and has no interest in me representing her, so I'm going to sit there.
I understand that. And Ms. Williams and I'm going to go through some things with Ms. Williams. I'm going to allow her some time to talk.
I can't hear you. You're going to have to speak up.
You need the hearing. We have hearing aids.
No, that's nasty, disgusting, dirty. You don't even.
All right. Well, I'm not.
No,
I'm
we
not
don't
going to
talk about
shout,
it.
Ms. Williams. I'm not going to shout. Okay. All
You
right.
did the first time, so.
No, I didn't. I've never shouted at you.
Well, then, do you have any other accommodations for handicapped people?
I have these hearing aids. They've been cleaned off and sanitized.
No, they're not. They've been cleaned off. They're not been replaced. I'm not putting something that's been in someone else's ear
All right,
in my own.
You obviously can hear what I'm saying to you, correct?
Because you raised your voice a little.
Okay, thank you.
But I didn't hear that.
Let's keep our tone civil if we can. Can we do that?
Yes,
can we
I
maintain
can.
civility in our discussion? I'm going to allow you
I
some time
talk
to
loud
talk.
because I'm deaf.
That brings us to the end of the second hearing, and the tension in the courtroom is clearly rising. The judge is becoming increasingly frustrated as the same behavior continues without change. As mentioned earlier, each appearance only adds more momentum to the situation. What follows is where the case truly begins to escalate. The third hearing marks the point where patience runs thin and the consequences start to become unavoidable. Let us move ahead to that next hearing and see how everything intensifies from there.
Okay.
So I'm just stating the fact that we talked about that prior, or the very first case I was here, I couldn't hear. So
Okay, we've had many conversations here on the record, and that hasn't been an issue before, but I'll do my best to speak
that's
up.
because you screamed at me last month, so I didn't have no problem hearing that.
All
So
right.
yeah, okay.
Ms. Williams, I didn't scream at you. Everybody in the world has seen the video you posted of our court proceeding
Yep.
here, okay, to include myself.
Only 600 something.
That's great. I have no problem with anything that I said in your case, so you do what you feel like you want to do.
The JQC had a problem with
It
it.
does appear, and I will say that it does appear that you properly requested through a public records request to get the recording of what we do here in
Yeah, I
court.
did.
And that's
Paid
what you
for it and
published.
everything.
I want to caution you and anyone who's with you that if you privately record anything in this
I ain't
court,
privately recording anything.
let me finish talking. Stop interrupting
just
me.
proving it.
Because
Sorry.
you need to hear this. If you privately record anything in this courtroom, then you'll be in violation of the administrative order that prohibits such recordings, and I will proceed with contempt
That's fine.
proceedings. Do you
As long
understand?
as they work, I'm good.
That camera's working, that camera's working, everything's being recorded. You request away under Chapter 119 for all the public records you want. I have no problem with anything I say here on the record, okay? All right, I understand all of the things that you filed. I want to make it clear for the record that there are several things that you filed that I have determined are not legally cognizable.
Some of them were just, just letters not
Sure.
meant to be.
Okay,
So,
I
yeah.
have stricken those things that I found to be legally not legally
What exactly
incognizable,
are
okay?
those things?
Again, you know how to do a public records request, so you can request your court file and get a copy
get
of the
ignored.
things, okay? Stop interrupting me when I'm talking, all right? I entered an order striking several of the pleadings. You did file one where you objected to the forced appointment of the public defender. And that, I believe, does legally trigger a Feretta hearing. And so I did set today to have a Feretta hearing with you, to go through the colloquy with you, to allow you to represent yourself if I find that you're doing that knowingly, intelligently, and voluntarily. Do you understand that?
We first have to establish jurisdiction on the record before we can do that.
No, jurisdiction is, I do not have to go, that's the...
You have to have both jurisdictions before you can proceed. You don't have either one of them. Neither one of them have been proven on the record.
All right. What is it that you think? I'm going to entertain you
I
for
already
just a
said
minute.
them to you.
What is it that you think? Well, say,
I have a whole
say
list.
it here on the record. What is it that you think compromises this court's jurisdiction right now?
Is constitutional violations. This court clearly does not honor the Constitution, so therefore it's not a federal court. It needs to be moved to a federal court because my rights were violated from the start. The initial traffic stop was unlawful.
Your charge of driving on a suspended license, resisting an officer without violence, and failing to register a motor vehicle, all violations of Florida statute, you say
Florida statute.
You say
I was exercising federal protected rights that Florida has to honor as well.
Ms. Williams, this is the nonsense part I'm talking about. This is what we've been through in the past, and this is. I cut you off last time simply because I didn't have time to go through this kind of dialogue.
You didn't have time when you were on the clock.
I sure did not have time to go through.
You saved my case for very last.
And look where you are now.
Yeah, now. Trying to prove me wrong ain't proving nothing wrong.
You should realize that actually having you go last might save you a little bit of public embarrassment, but here you are.
There ain't no embarrassment. I'm speaking truth, and you're silencing the truth to keep these people from learning their right.
No one here is trying to stop others from learning about their rights. The court is actually making an effort to protect you from creating more problems for yourself. Despite those efforts, you chose to publish these moments online, which only amplifies the situation. By doing so, you turned a private warning into a public record. The result is not exposure of hidden truths, but a clear display of choices and their consequences.
Let's go through the discussion about whether you represent yourself. Can we do that? And can we do that?
No, we have to discuss jurisdiction first. It has to be proven on the record before we can proceed. Otherwise, I don't consent to any proceedings before jurisdiction has been established.
As your lawyer, I can tell you.
You're not my lawyer.
If you let the judge go through this inquiry, then I'm not your lawyer. Then I'm officially not your lawyer. Then you can make your arguments.
Yeah.
There ain't no argument. The only argument is this judge does not honor our constitutional right. Doesn't honor the law.
I'm trying to go through the questions that I am required to go through under the law before you were to represent yourself.
You're required to do this too.
Okay.
We have to do this before. You don't have jurisdiction to even determine a Feretta hearing. That's why this has to be said first.
You think this needs to be in federal court and that I have jurisdiction?
My federal rights. You do not acknowledge or respect the people's right to travel in this country. Florida is in America. Our Constitution supersedes all state policies, laws, or whatever. And you're not accepting that. That's fact.
This is the part where you don't actually understand how
I do understand it works. Constitution was made for the simple man to understand. It's very easy to understand. Supreme Court has made precedents even more clear for people to understand. The very many that I sent you, which is absolute clear, you're refusing to acknowledge.
I actually read through several of those cases just to double check.
They don't have to be about being pulled over for no drivers. Like, it's all protected rights.
You're citing dicta, or you're citing holdings that apply to a different application of that constitutional right. None of those holdings.
They all have.
None of those holdings said that a state cannot require licensure.
Yes, it does.
For a driver?
Yes, it does.
No, it doesn't.
I will have them when we go to trial.
I can't have this nonsense discussion.
It's not nonsense.
We can't get anywhere.
You're not recognizing it as truth, so you're calling it nonsense.
Will you go through the Feretta inquiry with me? Because if you will, then we can have this. No,
that would be me giving you jurisdiction over me in this case, and I'm not going to do that.
All right.
You have to acknowledge the personal jurisdiction. I have a whole list here. We can go over each one if you want.
I want to allow you to represent yourself if you can go through those questions with me. But if you continue to be obstreperous the way
Let's
you
go
are
through
right
these
now,
first before we can go through that.
Here's the other part about court and jurisdiction is that you, Ms. Williams, as the defendant in court, do not get to tell the court how to conduct procedure in court.
A court
And
cannot
you need to-
determine its
you
own
need to understand that
jurisdiction.